Welcome, deep divers. Today we're taking a deep dive into a really crucial piece of legislation. It impacts pretty much everyone in the workforce, South Africa's Employment Services Act of 2014. So if you're looking for a job, maybe hiring someone or, maybe even a law student trying to untangle these legal frameworks, this deep dive is definitely for you. We've gone through the act itself, its chapters, schedules, all that stuff to pull out the really important bits. Our aim, to explain this act in a way that's, well, clear and engaging. We'll look at its core purpose, the key rules, how it fits into the bigger legal picture, and what it actually means for you in the real world. So, what's our mission today, beyond just laying out the facts?
Yeah, our mission is really to make this act super accessible and insightful. We'll cut through some of that legal jargon, definitely, and show you how it connects to other vital laws. You mentioned the Immigration Act, the Basic Conditions of Employment Act, and really highlight the practical side of things. We want you walking away with those aha moments, understanding how this act shapes the job market here, ensures fairness, provides actual support, connecting the dots between the law and everyday work life.
Excellent. Sounds good. It was signed off April 3, 2014, mostly started August 9, 2015. Latest update was that same date, so it's foundational, but still relevant.
Yeah.
Okay, let's get into it. What was the main sort of driving force behind creating this act? What problems was it really trying to solve?
Well, at its core, the Employment Services Act has this multifaceted purpose. It's aiming to promote a more equitable and efficient labor market for everyone. And for you, whether you're the work seeker or the employer, understanding these goals really helps clarify why certain rules are there, how they're meant to create opportunity and fairness.
Okay, so promoting employment is the obvious one. But what's a purpose you think people often miss, or maybe one that's particularly ambitious within the act?
That's a great point.
Okay.
Because, yeah, you'd expect an Employment Act to focus mainly on local workers, right? But a really crucial, maybe surprising purpose is how it handles foreign national employment. It's a delicate balance. It's not just about letting foreign nationals work. It's about doing it without hurting South African workers or lowering labor standards. And what's really forward-thinking is the requirement for skills transfer.
Skills transfer.
Yeah, transferring skills to South African citizens and permanent residents. That's designed to benefit the country long-term. And this, along with upholding fair labor practices from Section 23 of the Constitution for everyone, shows a remarkably nuanced approach.
That's fascinating. So it's not just filling jobs, it's about strategic contribution. How does the act actually plan to achieve all this? It sounds like a huge undertaking.
It is, definitely. But the Act lays out clear ways to do it. First off, it promises comprehensive and free public employment services. That's fundamental. Think of it like government-backed support. It also works by coordinating different public agencies, encouraging partnerships between sectors, setting up specific work schemes for certain groups. And finally, really importantly, it provides that much-needed regulatory framework for private employment agencies, making sure they operate ethically.
Right. So it's not just floating out there on its own. It's part of a bigger legal system. How does it fit in? What other laws does it connect with or lean on?
You nailed it. It's definitely not an island. The Act itself says you have to interpret it in line with its own purpose. The Constitution, especially Section 23, on fair labor practices for everyone, including foreign nationals and South Africa's international labor obligations, treaties and standards. Plus, it's deeply tangled up with other key laws. Basic Conditions of Employment Act, Labor Relations Act, Immigration Act, Skills Development Act, even the Public Finance Management Act. It's all part of this complex ecosystem governing work.
Okay, a whole ecosystem. And who's in charge of making it all work? Who actually implements these rules on the ground?
That job falls to the Director General of the Department of Labor. They need to make sure the department, including provincial offices and those crucial labor centers, has the people and the money. Those labor centers are really key because that's where you, the public, can directly access many of the free services the Act promises.
So the labor centers are the face of it for many people. Okay, that brings us to Chapter 2. The public employment services the department has to provide, free of charge. What does that actually look like for someone looking for a job?
Absolutely. So imagine you're, say, a new graduate or maybe switching careers, feeling a bit lost in the job market. This act says the department must offer core services, all free. That means matching work seekers with job openings, helping register yourself or vacancies, facilitating placements. They also give advice on education, training, even Social Security benefits. And really importantly, they offer specialized services for vulnerable work seekers, people who might face bigger hurdles finding work. It's basically a public resource to connect everyone in the market.
That sounds like crucial support, especially for those who need it most. Are there also specific programs, maybe for young people or to help people keep their jobs when times are tough?
Yes, exactly. The Act covers both. For promoting youth and vulnerable work seekers, the minister can set up special work schemes. These are designed to help them get into work, stay employed, or even start their own thing. And importantly, basic employment conditions still apply in these schemes. Then there's job retention. For companies in economic distress, the minister can create schemes to minimize layoffs. Think turnaround plans, maybe temporary layoffs, retraining, finding alternative jobs. It's about softening the blow during hard times.
That's real help for people and businesses facing tough times. Okay, let's switch gears a bit to that complex topic. Foreign nationals. What does the Act clarify about employing them?
Right, this is a key area with very clear rules for employers. The Act is blunt. An employer cannot hire a foreign national without a valid work permit from the Immigration Act. Full stop. That's a big legal duty on the employer. The minister can also bring in regulations requiring employers to check if suitable South African skills are available first before hiring a foreign national. They might even need to create skills transfer plans. It's about being deliberate.
So employers have to do their homework. But here's where it gets really interesting. For the work of the Act, give them strong protections, even if the employer messed up.
Right, exactly. This is one of those aha moments. It's fascinating and incredibly protective. An employee hired without a valid permit can still enforce claims against their employer under any law or employment relationship.
Wow. Okay.
Yeah, it's a massive safeguard. It means an employer can't just exploit someone undocumented and then say, oh, you had no permit, so no rights. The law ensures basic labor protections stick. Plus, employers can't make foreign nationals do work they aren't authorized for or work outside the terms of their permit.
That's a really vital distinction.
Yeah.
Protecting people regardless of permit status. What about information? The department needs to know what's happening in the job market.
Precisely. The Act lets the minister require employers to report vacancies, new jobs, or when they hire someone referred by a labor center. It gives transparency. The department can also set up a big employment information system to track trends, qualifications of job seekers, vacancies available, training options, employer details. That data is gold for making policy and providing services effectively.
And running all these services and systems, where does the money come from? It must cost a fair bit.
The main funding for public employment services comes from the department's budget, but it can also draw from the Unemployment Insurance Fund and the Compensation Fund. There's even a possibility of using money from private agency registration fees if the finance minister agrees, and they can accept grants and donations. Crucially, this money is earmarked for specific things. Administration, those schemes for vulnerable and retrenched workers, rehab for disabled individuals, subsidies, even paying private agencies for specific projects.
Okay, a mixed funding bag for a lot of different services. Now let's shift to those private employment agencies, the ones many of us use. What does this act mean for them, and how does it protect people using their services?
Chapter 3 really gets into private employment agencies. It sets up a pretty strict system. It demands registration for all agencies. The minister sets the criteria, even distinguishing between temp agencies and others. There's a registrar to handle applications. And the core rule: nobody can run a private employment agency unless they're registered and stick to the rules of that registration. It draws a clear line in the sand. Though it's worth noting, last time we checked, the full enforcement of that specific registration section was still waiting for final proclamation.
Okay, significant oversight then. What are the big don'ts for these agencies? What should job seekers be really careful about?
This is where some key protections kick in. Agencies are banned from giving false info, doing services they aren't allowed to, or messing with their certificates. But here's a really, really important practical point for you, the job seeker. Agencies cannot keep your original ID documents or original qualification certificates.
Ah, that's crucial.
Absolutely. It's a fundamental protection against potential abuse. It means you always control your vital personal documents. It empowers the individual.
That's a massive weight off people's minds. Those documents are so important. What about fees? That's always a worry for job seekers.
This might be one of the biggest protections in the whole act for job seekers. The general rule, stated clearly, is no person may charge a fee to any work seeker for providing employment services.
No fees at all.
Pretty much. There can be rare exceptions if the minister approves them for very specific job categories or specialized services published in the Gazette. But the default is 0 fees for the job seeker. Agencies also can't deduct placement costs from an employee's wages or make an employee pay such a fee. When they bill a client, The agreement must show the employee's pay and the agency's fee separately. No hidden costs. Any agreement that breaks this is invalid, and disputes go to the CCMA or a bargaining council. It puts the cost burden firmly on the employer, not the person looking for work.
That clarity on fees and protecting documents is huge for individuals. What about handling all that personal data they collect?
Sections 16 and 17 cover that. Agencies have to retain information, keep registers, electronic or paper, of work seekers, placements, employer details for at least 3 years. That's for accountability. And confidentiality is paramount. Personal info must be protected, privacy respected, and used limited to qualifications and experience. Sharing that info is tightly restricted, usually only to potential employers, the department sometimes, or other state bodies if legally required.
And if an agency breaks these rules, what happens then?
There are consequences. If they don't comply, the registrar can move to cancel their registration. It's a formal process. They get notified, get a chance to explain themselves. If registration is canceled, they're off the register, can't operate. And importantly, if someone feels unfairly treated by a decision not to register them or to cancel their registration, they can ask the labor court to review it within 30 days.
Okay, so there's accountability and a way to appeal. Now, behind the scenes, there are some key players making this all work. Let's talk about the Employment Services Board.
Right. Chapter 4 sets up the Employment Services Board. It's mainly an advisory body for the minister. Its composition is really important. You've got an independent chair, 3 state reps, then 3 people each from organized labor, organized business, and community development groups. These are nominated by NEDILAC, the National Economic Development and Labor Council.
NEDILAC, right.
Yeah.
Where government, labor, and business hash things out.
Exactly. So that composition ensures a really wide range of views feed into the board's advice.
So it's bringing everyone to the table. What are its main jobs? What does it advise on?
Its functions cover a lot. It advises the minister on creating work opportunities, the rules for registering and deregistering private agencies, how to implement and enforce the act. Crucially, it also guides policy on promoting supported work for people with disabilities. Plus, it advises on regulations, the annual Employment Services Report, and anything else the minister or NEDLA asks it to look at.
Sounds like a key strategic body. You mentioned disabilities. There are other specific bodies created too, right?
Yes, absolutely. Moving beyond the board, Chapter 5 establishes Productivity South Africa. It's set up as a juristic person, basically, a legal entity in its own right. Its main goal is promoting employment growth and productivity across the board. It does this by fostering a productivity culture, developing skills, measuring improvements, keeping databases, doing research, and supporting efforts to prevent job losses.
And the ones specifically for persons with disabilities.
That's in Chapter 6. Supported Employment Enterprises, or SEE. This is set up as a national government component. Its whole focus is promoting work and jobs for people with disabilities. Its functions include facilitating supported employment, actually providing work opportunities, and running programs to boost employability for people with disabilities, including permanent disablement. And there's a neat historical link here, but the assets and duties of the old service product factories set up way back in 1948 were transferred directly to SEE. It shows this long history of evolving support.
Okay, all good structures and rules, but how does the Act actually make sure people follow them? What are the teeth?
Chapter 7, Enforcement, Offenses, and Penalties, gives it those teeth. The Labor Court has exclusive power over all matters from this Act, except criminal stuff, and can review administrative decisions. For everyday checks and enforcement, the Act points to Chapter 10 of the Basic Conditions of Employment Act. So enforcement officers have similar powers to investigate and ensure compliance.
And those fines can be serious, right? You mentioned R50,000 earlier. What triggers that kind of penalty?
That R50,000 fine is definitely meant to get attention. The labor court can hit an employer with that for specific violations listed in Schedule 3. Things like a private agency not displaying its certificate, giving false info, or, and this is a big one, charging a fee to a work seeker when they're not allowed to.
Right, the fee thing.
Exactly. Also, illegally deducting placement fees from wages, not keeping proper records, or breaching confidentiality, those can all trigger that fine. Well, these are very practical things employers and agencies need to watch out for.
Significant deterrence. What about even more serious stuff?
Yep.
Can people actually face criminal charges?
Oh, yes. Section 50 covers offenses and penalties that are criminal matters. Things like getting documents fraudulently, lying officially, or blocking inspectors doing their jobs. For those, you could face up to 12 months in prison or a fine. And operating a private agency without registration or breaking its terms, that can mean up to 24 months imprisonment or a fine. Also, breaking the rules about hiring foreign nationals, like employing without a permit or outside its terms, leads to penalties defined in the Immigration Act itself. So yes, the consequences can be severe.
Clearly, the act isn't messing around. What about keeping it up to date? Can powers be delegated?
Yes, the minister can delegate most powers to the director general, things like making regulations or appointing some board members or exceptions. This helps with day-to-day running. And the minister can make regulations after talking to the relevant boards on details like reporting vacancies, work seeker registers, agency registration rules, complaints procedures. This keeps the act flexible and responsive.
And lastly, how does this act fit with older laws? What did it replace or build on?
Good question. It includes sections on repeal of laws and transitional provisions. It specifically got rid of parts of the 1998 Skills Development Act that dealt with employment services and the original Productivity South Africa. But to avoid chaos, there are transitional provisions. Existing private agencies registered under the old act were considered deemed registered under this new one. However, they had to reapply within 2 or 3 years, depending on the type of service they offered. It ensured a smooth but definite shift to the new system.
So there we have it, a pretty thorough deep dive into the Employment Services Act of 2014. From boosting jobs for vulnerable groups to tightly regulating agencies, creating bodies for productivity and disability support, it's quite a comprehensive framework.
It really is. We've seen how it tries to make the labor market easier to access, protect workers, and make sure public and private players operate fairly and legally. For you, listening, whether you're job hunting or hiring, understanding this stuff isn't just about rules. It's key to navigating the system well, responsibly. It helps build a better work environment overall.
Absolutely. It's a living example of how laws try to keep up with a changing economy and society. A reminder that the world of work never stands still, and neither do the rules. So as you think about all this, here's a final thought to chew on.
In a world that's increasingly global and with automation changing jobs constantly, how might these core ideas promoting employment, protecting workers, managing foreign skills need to evolve in future versions of this act? What new challenges or maybe opportunities does that future hold for you personally in the labor market?
A really great question to ponder. Thanks for joining us on this deep dive into the Employment Services Act 2014. Until next time, keep digging, keep learning, and stay well informed.